Chairman and members of the committee, good morning. I offer this testimony, obviously, in my capacity as Attorney General, but as some of you may know, I taught for 15 years as a professor of constitutional law at UMKC Law School and taught Second Amendment law. So hopefully I can offer some answers to questions you may have about how this fits into the legal framework we have right now. I'm strongly in favor of HCR 5020. I believe that the robust protection of our right to keep and bear arms is not only consistent with both our state and federal constitutions and the intentions of the framers of both the state and federal constitutions, but it's also essential to a free society and the protection of other constitutional rights. But I think the best value I can add for this committee is to try to explain what this constitutional amendment would do. What effect would it have? And I think in order to do that, you need to begin with two things. What power does a state constitutional amendment have in litigation? And secondly, you have to look at this in the wake of the Supreme Court's decision on June 23rd of 2022 in the case of New York State Rifle and Pistol Association versus Bruin. Okay, so let's look at the first thing. What can a state constitutional right do? A state constitutional right can elevate the level of protection for whatever right we're talking about. So it doesn't matter whether we're talking about the right against searches and seizures, the right to worship, the right to free speech, the right to keep and bear arms. If the federal constitutional right takes you here, the state constitutional right can add more protection. Now, let's say that the state constitution doesn't say anything, or the state constitutional right protects it to a lower degree. It won't work the opposite way. It won't reduce what the Second Amendment does for you, but it can add more on top of the Second Amendment. The second thing you should know about state constitutional rights, they can be preempted. So a federal statute can override a state constitutional provision. However, a federal regulation promulgated by, say, ATF cannot override a state constitutional provision. So that's the first thing we want to keep in mind. Second, we need to talk about the June 2022 case in Bruin. In that case, the Supreme Court recognized that the Second Amendment does protect the right of a person seeking to get a concealed carry permit without a special reason. New York had didn't have a shall issue law; they had a may issue law, where a state official could basically decide whether you had a good enough reason to have a concealed carry permit. The Supreme Court struck it down, but the Supreme Court did more than that. The Supreme Court set a very high constitutional standard for protecting Second Amendment rights. Now, in DC versus Heller in 2008, the Supreme Court for the first time affirmed that the Second Amendment is an individually held right on par with other individually held rights. Prior to that, there have been theories that it could only be held by members of the militia or National Guard, and there were all kinds of theories. But the Supreme Court said, no, it's like all the other constitutional rights. It was presumed by many that would mean that strict scrutiny would apply. Whenever in strict scrutiny, to answer your question, strict scrutiny means that the law is presumed unconstitutional, but the government has the burden, if the government is to prevail, must show there's a compelling governmental interest and that the law is necessary to serve that interest. Very high standard. But what happened is several of the federal circuits applied something closer to intermediate scrutiny, which is that the government has an important government interest and that the law substantially advances that interest. Then fast forward to last year, or 2022, with the Bruin case. The Supreme Court said, many of us thought, oh, they're just going to say no, strict scrutiny applies. They went one step even higher. And they said, if you can show that this right falls within the text of the Second Amendment, then the law is presumed unconstitutional. The only way the government can win is if the government can show that the regulation at issue is consistent with regulations that were understood to be okay at the time of the framing. In other words, understood to be okay in the 1789 to 1791 period. That's a higher standard. It's an absolute standard. There's no balancing as there is with strict scrutiny. There's no weighing of the government's compelling interest. Okay, so what does that mean for this Kansas amendment? What it means is that we would be adding a strict scrutiny standard for the state level. And I think that's a good thing if you believe in protecting gun rights, because if for some reason a regulation failed to meet the history and text test that the Supreme Court just created, again, this is a freshly created test in 2022, you still might be able to achieve pass the strict scrutiny test. In other words, the right might be better protected conceivably under strict. So you basically have two very strong tests protecting the individual. In litigation like this, the plaintiff or the person asserting the constitutional right will usually assert every constitutional claim he has. So he will bring both a Second Amendment claim and a claim under the Kansas Constitution. So by adding the strict scrutiny standard, in addition to the Supreme Court's new text and history standard, you're giving the person asserting the gun rights the best possible chances. The other way it'll affect litigation is this constitutional amendment specifically mentions ammunition and components and accessories. I think that's a good thing. The Supreme Court has yet to address whether the Second Amendment extends to those things. I think it does, but there's no case law yet in the United States Supreme Court. So it does two things. It gives the individual asserting the right the strict scrutiny standard in addition to the Supreme Court's new standard. So you've got two different ways of prevailing, and it also expressly protects accessories. I would end my testimony, and I'm certainly happy to take questions, with one note of history, and that is Kansas history. As was mentioned in 2010, the voters of Kansas did ratify the amendment of the text of this amendment as it stands now. But what you may not remember is that 88.2% voted yes. That's the highest percentage voting in favor of a gun rights amendment of any state ever in United States history. Kansas set that high bar in 2010. Second place goes to West Virginia in 1986 with their amendment when they hit 83.6%. I just mentioned that to say that the voters of Kansas, at least in 2010, were strongly in favor of protecting our constitutional right to keep and bear arms. I anticipate that they will be strongly in favor of it this year as well. Thank you.
Very good. Thank you for that. Committee, are there questions? Representative Hoy.
Thank you, Mr. Chair, and thank you, Mr. Attorney General, for the testimony. I do think that is helpful to understand how this is applied in court, but I do want to also paint the picture of when we're talking about the cases going before the courts and the cases that would be subject to strict scrutiny. A lot of these that the other states are seeing, they're not coming from law-abiding gun owners. It's coming from convicted domestic abusers, convicted felons. And there's nothing in this amendment that would protect our convicted felon prohibitor. There's nothing that would that states in there that those are the types of laws that we would want to protect. And so I am very concerned about how costly that could get at the expense of the taxpayers to be defending ourselves against potentially violent criminals. So what are your thoughts on how that is, even if it does withstand? Other states that have done this have seen floods of litigation, and I am concerned about some of these laws that have passed. I mean, the domestic violence bill passed overwhelmingly from the legislature. That's something we've all agreed is a common sense gun law that's already on the books, and this could potentially take some of those laws off of the books.
I respectfully disagree that it would take those laws, or that it would have the effect of nullifying those laws in court if they were challenged. The reason is that in both federal Second Amendment jurisprudence and in the text of this case, it's always been assumed that historically and today, the government, whether it be the federal government or the state government, has the right to take away from a felon his right to keep and bear arms. That that right can be sacrificed, and that the loss of that right is an element of punishment that can be imposed. And I think if you look at the existing wording of the Kansas constitutional provision, it has those words lawful, and that's important. Right to keep and bear arms for defense of self, family, home, and state, for lawful hunting and recreational use, and for any other lawful purpose. That's the existing language we have. That doesn't change. And that lawful purpose, lawful uses, is suggestive of what we've seen in other cases involving the federal constitutional Second Amendment, where because you have acted unlawfully, you have lost or forfeited your right to keep and bear arms. So I don't think this would change or undermine federal. Well, it certainly wouldn't undermine federal statutes. And bear in mind that it's federal statutes that have the effect of depriving most people of their right to keep and bear arms. It's usually not, although the state. We do have a statute that says that a felon can, it is a felony to be in possession of a firearm when you are disqualified for holding that firearm. That's parallel to a federal law, which would still be in effect. So the federal statute wouldn't be affected by this Kansas constitutional change at all.
Correct, but for clarification, if we don't have that mirroring law like we do with the domestic violence language in our state statutes, then it takes a local and state law enforcement aren't really able to enforce it. So it'd be up to federal agents, which I would also caution law-abiding gun owners, if this would go into effect, they could still end up in federal prison, even if the state doesn't have a case against them. But to clarify on to the protection of these existing prohibitors, if even a moderate judge, if there's one component of something that they strike down that is being of a law or statute that's being challenged, that could strike the whole law. It wouldn't just be one part of it. So if we're looking at our domestic violence, if a domestic abuser sues the state, if this goes into effect and says that our domestic violence law is unconstitutional to the Kansas Constitution, that could potentially put that at risk. I mean,
Well, as you go, it depends on the law. And I assume, I don't have it in front of me, I'll assume that our domestic abuse statute has a severability clause. You guys routinely put severability clauses at the end of every statute, virtually every statute you pass. The reason you put that there is so the court can sever the offending provision and the rest of the statute stays. I'm guessing we have a severability clause. We have with most of our statutes, but that would prevent the whole domestic violence statute from going down.
Very good. Thank you. Representative Clayton.
Thank you, Mr. Chair, and thank you for being here, Mr. Attorney General. I figured very rarely do I actually get to have the Attorney General in front of me, and I know that you have a very solid education, so I know that you will be able to clarify this for me. I'm not even trying to troll you here. I legit want to know. I looked up our definition of, basically like our types of firearms and things that are illegal. The only ammunition that is illegal in Kansas under Kansas statute is bullets that have plastic interiors, right, or plastic casing. So that's it's KSA 236301 if you all want to pull that up in your laptops, section 6 that covers ammunition. But so this would be a constitutional amendment, right? And so ammunition is mentioned. I know that there are federal regulations against armor piercing ammunition. Would this override those? Because I'm kind of freaking out here. So can you assuage my concerns on that, please?
So all federal statutes governing ammunition and the very high, more deadly military type ammunition would still apply. The state constitutional amendment would not override a federal statute. I would also just say, just as an aside, the definition armor piercing is not like it's not like a bright line, right? There are 5 different categories of body armor you can wear, and I know this personally because KBI has given me all these options, and here's what you do. So there are different levels, and then bullets, of course, have many. There are many grades of bullets. It's not like one that just crosses the line and becomes armor piercing. So anyway, there are federal restrictions, statutory restrictions on the most potent bullets. Those would remain in place.
But just to follow up here, so there are federal restrictions against the most potent, the most armor piercing, but there are some that are armor piercing light that wouldn't be made illegal.
I mean, I'm not a armorer, but I can tell you that some, those of you who do shoot know that some bullets will, if it's a solid projectile, may actually pierce the armor, but they may not be as effective. They might be as deadly because it's a solid. It doesn't, come apart when inside the target. So it'd be hard to answer your question with a definitive yes. This type of bullet, which is really deadly and will go through the armor, would change. But the general answer to your question is nothing changes because most of these restrictions, virtually all of these restrictions, except for the Kansas one you mentioned, are federal statute anyway.
All right. Well, you have raised some concerns just regarding the different types of armor piercing bullets. I was really raised to respect and protect law enforcement. And so I just don't feel comfortable supporting this. But I do appreciate you being here today, Mr. Attorney General. Thank you.
Welcome.
Representative Ruiz.
Thank you, Mr. Chairman. And it's good to see you again, Mr. Kobach. Has been any specific threat to the Second Amendment rights to the citizen of Kansas that precipitated this bill coming forth?
Well, I think there's, it's hard to define a specific threat. I think if you think about threats to the Second Amendment, usually Unfortunately, those often come from the government, typically the federal government. And in the current administration in Washington, the ATF has been pressed to stretch the limits of its statutory authority and do things that the federal statutes, in my opinion, do not authorize. They're going beyond their statutory authority. And so they've done a host of things. For example, Kansas is, we are leading a 25-state group that are saying there's currently an ATF proposed regulation that would essentially make person-to-person individual transactions between two friends or between family members, if there is any profit whatsoever made in the sale of the firearm, that would be illegal unless the seller obtains an FFL, a federal firearms license. So the ATF has been, in the last 3 years, aggressively redefining the regulations, trying. They've been challenged in court. And so I think that's the threat, is that if you have a federal regulatory agency that's going beyond its statutory authority and arguably violating the Second Amendment, we'll see it when these cases get to the high court, then that's a threat to Second Amendment rights. And again, a state constitutional amendment does have effect against a regulatory agency, in particular when that agency is exceeding its statutory authority. It does not trump Congress, though.
Getting back to the accessory part of the bill, what about bump stocks?
I think bump stocks are fairly categorized as an accessory. However, as you know, that case is in litigation right now, and the question is, are bump stocks within the protection of the Second Amendment? So that might be something that would be categorized as an accessory. I think the courts are probably going to view it that way.
And my final question, people seem to really revere the Second Amendment above all amendments in the Constitution. We're all sworn to protect the Constitution of the United States and the state of Kansas. Do you hold all amendments sacred like the Second Amendment in the Constitution?
Absolutely.
Thank you. Thank you, Mr. Chairman.
Very good. I have a couple more folks, and then we'll cut this off in the interest of time. We have other people here that need to speak. So with that, Representative Haskins.
Thank you, Mr. Chair, and thank you, Attorney General, for your testimony. And my questions have been asked by my colleagues, except I wanted to just clarify, will this have an impact on your office for the taxpayers to cover? Will this be challenged? Do you anticipate, since we don't have a fiscal note?
It's really hard to predict litigation. And the most likely litigation would be brought by an individual, right? It's an individual asserting that his right to keep and bear arms has been infringed. He would add this more robust state constitutional element to his challenge. The only way it would affect our office is if the individual was challenging a state statute, and of course it falls to my office to defend that statute. So it's conceivable that it would come into play in such a case.
So if it does, thank you, Mr. Attorney General. So if it would come to play here, here's the two other questions I have on that. Is like, I'm still not sure, has there been a demand and from your law enforcers and from the citizens stating like this amendment is needed?
There's been a lot of concern and outcry among citizens that I have spoken to, worried about what the ATF, the federal bureaucracy, has been trying to do to go beyond the scope of the four corners of federal statute.
But there's no coherent support explaining why this amendment is necessary. It's just information that you've received from citizens overall. Is that?
Well, I think most citizens, are not attorneys and may not be thinking, okay, how would you fortify your right to keep and bear arms? But I think this significantly does, as I tried to explain, significantly adds to the protection of the right.
And my final question is let's say the federal government comes down and says that one of these firearm accessories is illegal, and then all of a sudden ATF takes away Kansas citizens' arsenal that has this illegal, and they want to sue based upon this, their state constitutional right. How would you side on that?
So if the federal Congress banned a particular type of accessory, and there are lots of bills in Congress to do exactly that, then this amendment would it would be preempted by that congressional act. Now, if ATF tried to expand its authority beyond what it has right now under this federal statute and tried to ban that accessory, then the individual would have a claim here. It probably wouldn't affect us because the defendant, it depends how the case, maybe the ATF seizes something from an individual or from a seller, and then that individual is a defendant asserting in a criminal case the right to keep and bear arms. The state of Kansas wouldn't be a party in that case.
Okay. I'm sorry. Last question, Mr. Chair. I promise. So if the federal government, if we're going to follow the federal government's laws based upon what is ammunition, what is the gun accessory that's legal, why is this necessary? Because it seems like the federal government is already, and we're going to follow that. And the language in here is so broad that it doesn't really give any generalization stating like, would we support the federal constitution first, or would we support state constitution? It just says you have the right to own bullets. And I would think that the Second Amendment would already cover that.
I would think the Second Amendment would already cover the right to own ammunition. But one of the interesting things about the Second Amendment is it's not the least developed amendment. The Third Amendment, which is the right not to have soldiers quartered in your home, is probably the least opined on. But the number of cases that squarely address what the Second Amendment means is fairly small. I mean, you really, as someone looking at it as a constitutional lawyer, you'd look at Heller, then you'd look at McDonald versus Chicago, and then you'd look at New York State Rifle and Pistol Association versus Bruin. Prior to that, you had to go back to the 1930s to see a Supreme Court decision on the meaning of the Second Amendment. I say that to answer your question. There are still a lot of unanswered constitutional questions. To what extent is ammunition covered? What accessories, if are covered, what aren't covered by the Second Amendment? What this would do would add certainty that the state constitutional provision in Kansas does cover those things.
Very good. Thank you. One more question. Committee, I will remind you to be respectful of our conferees. Let them finish their answers before you interrupt. So with that, I have one final person, Representative Haswood.
Thank you, Mr. Chairman, and thank you, Mr. Attorney General, for being here today. These are conversations and topics that we don't take lightly in here. And my mind goes to public safety and wellness of Kansans. And my mind goes to, what are the consequences of this? What doors are we opening, whether it be domestic violence? And I know in the spaces of firearm, school shootings and our children's safety and wellness are always of concern. I'm concerned that this is going to be opening up the doors for folks to get in the wrong hands of these ammunition accessories and dangerous components. I was just asking for a clarifying question. I think you guys were talking a little bit about this, but domestic violence, what are the potential, consequences that this might bring for those folks?
So you also mentioned, I'll answer your question, but you mentioned in your preface the, concern about school shootings. There's a federal statute, the Gun-Free School Zones Act, which was passed in, I think, 1990 or 92 under President Bush. That remains in effect. So that doesn't change. And again, it would not be a lawful use of a firearm to take that firearm, unless you're a law enforcement officer, into that school. So that doesn't change at all. It's still unlawful. And this amendments to our constitutional amendment doesn't change that. With respect to domestic violence, if the individual has been convicted and is deprived of or a court has issued an order depriving the individual of the right to bear arms, this would not displace that order. You could make the case that maybe on the margin someone might raise this as an argument, but I don't see this as changing the outcome in a domestic violence situation.
Okay, thank you.
Very good.